Question 1. Market research demonstrates that a registered securities agent in California has become aware that an individual associated with their firm, but not formally registered with the California Securities Division, has been actively soliciting investments from potential clients. The agent has observed this individual making specific investment recommendations and receiving funds. What is the most appropriate course of action for the registered agent to take to comply with California securities regulations and mitigate potential liabilities? Option A. Ignore the unregistered individual's activities, assuming they will eventually stop on their own. Option B. Advise the unregistered individual to cease all activities and handle the situation internally without regulatory notification. Option C. Immediately report the unregistered individual's activities and the associated risks to the California Securities Division. Option D. Continue to monitor the situation internally and only report if the unregistered individual's actions lead to formal complaints. The correct answer is C. Immediately report the unregistered individual's activities and the associated risks to the California Securities Division. Explanation. Scenario analysis. This scenario presents a professional challenge because it involves a registered agent's potential liability for actions taken by an unregistered individual associated with their firm. The agent must navigate the complex web of state securities regulations to determine their responsibility and the appropriate course of action to mitigate further harm and comply with the law. Misinterpreting the scope of their liability or the reporting requirements could lead to significant penalties. Correct approach analysis. The best professional practice involves immediately reporting the unregistered individual's activities to the appropriate state securities regulator in California. This approach is correct because Section 25,245 of the California Corporations Code and related administrative rules impose liability on broker-dealers and their agents for the actions of those acting on their behalf, even if those individuals are not formally registered. Prompt reporting demonstrates a commitment to compliance, allows the regulator to investigate and take necessary action, and can potentially mitigate the agent's own liability by showing proactive engagement. Incorrect approaches analysis. Failing to report the unregistered individual's activities to the California Securities Division is a significant regulatory failure. This inaction allows potentially illegal securities transactions to continue, exposing investors to risk and violating the agent's duty to uphold securities laws. It also constitutes a failure to cooperate with regulatory oversight, which can lead to more severe penalties. Attempting to handle the situation internally without involving the California Securities Division is also professionally unacceptable. While the agent may believe they can rectify the situation, this bypasses the regulatory framework designed to protect the public. The agent lacks the authority to conduct a formal investigation or impose sanctions, and their internal efforts do not absolve them of their reporting obligations or potential liability. Ignoring the unregistered individual's activities and hoping the situation resolves itself is the most egregious failure. This passive approach demonstrates a blatant disregard for regulatory requirements and investor protection. It exposes the agent to maximum liability for any damages caused by the unregistered individual and can result in severe disciplinary actions, including fines, suspension, or revocation of their registration in California. Professional reasoning. Professionals facing such situations should first understand the scope of their firms and their own responsibilities under the relevant state securities laws. This includes recognizing that liability can extend to individuals acting on behalf of the firm, even if not formally registered. The immediate next step should always be to consult the firm's compliance department, and then to report any suspected violations to the state securities regulator promptly. Documenting all communications and actions taken is also crucial. Question 2. Implementation of a seminar in California by a financial planning firm discussing general economic conditions and market trends. What approach best ensures compliance with California's definition of an investment advisor and avoids inadvertent registration requirements? Option A. The firm presents general market trends and economic outlooks, and then discusses hypothetical investment strategies that could be employed in various market conditions, without explicitly stating that these strategies are not personalized advice. Option B. The firm distributes generic model portfolios and investment allocation charts to all attendees, suggesting these are examples of sound investment approaches. Option C. The firm clearly states at the outset and in all distributed materials that the information is for educational purposes only. No specific investment recommendations will be made, and attendees should consult with a qualified professional for personalized advice tailored to their individual financial situation and objectives. Option D. The firm answers attendee questions about whether specific securities are good buys for their personal portfolios, while verbally noting that it is not personalized advice. The correct answer is C. The firm clearly states at the outset and in all distributed materials that the information is for educational purposes only. No specific investment recommendations will be made, and attendees should consult with a qualified professional for personalized advice tailored to their individual financial situation and objectives. Explanation: this scenario presents a professional challenge because it requires distinguishing between providing general information and offering personalized investment advice, a critical distinction under state securities laws. Misinterpreting this line can lead to unintentional registration violations and regulatory scrutiny. Careful judgment is needed to ensure compliance while still effectively communicating with potential clients. The best professional practice involves clearly delineating the scope of services offered. This approach correctly identifies that providing specific recommendations on securities, even if framed as educational, constitutes investment advice if tailored to an individual's financial situation and objectives. By explicitly stating that no specific investment advice will be provided, and that all information is for educational purposes only, and by avoiding any discussion of specific securities or portfolio allocations relevant to the individual circumstances, the firm remains compliant with the definition of an investment advisor in California. This aligns with the spirit and letter of the California Corporate Securities Law of 1968, which aims to protect investors by ensuring that those who provide investment advice are properly registered and held to a fiduciary standard. An incorrect approach involves presenting general market trends and economic outlooks as a basis for discussing potential investment strategies without clearly disclaiming the provision of personalized advice. While the information might be broadly applicable, if it is presented in a context that implies it is tailored to the attendee's specific financial situation or investment goals, it can cross the line into providing investment advice. This fails to adequately protect the attendee from potentially acting on information that is not suitable for their individual needs and may inadvertently trigger registration requirements for the presenter. Another incorrect approach involves distributing generic model portfolios and investment allocation charts without any accompanying disclaimers or context. While these materials may be illustrative, their distribution without clear guidance that they are not personalized recommendations can lead attendees to believe they are receiving specific advice. This bypasses the regulatory requirement to ensure that investment advice is provided by registered individuals or firms, and can mislead investors into making decisions based on information that is not appropriate for their unique financial circumstances. A further incorrect approach involves answering specific questions about whether a particular security is a good buy for an individual attendee, even if the presenter qualifies their answer by stating it is not personalized advice. The act of directly addressing the suitability of a specific security for an individual, regardless of disclaimers, strongly suggests personalized investment advice. This directly engages in the type of activity that the California Corporate Securities Law seeks to regulate through investment advisor registration. Professionals should adopt a decision-making framework that prioritizes clarity and compliance. This involves 1. Understanding the precise definition of an investment advisor and investment advice under the relevant state law, in this case, California. 2. Proactively structuring all communications and materials to explicitly avoid the provision of personalized recommendations. 3. Using clear and unambiguous disclaimers that define the scope of information being provided and what is not being provided. 4. Training personnel on these distinctions and the potential regulatory consequences of missteps. 5. Regularly reviewing client interactions and marketing materials to ensure ongoing compliance. Question 3. To address the challenge of accurately identifying when an individual's activities necessitate registration as an investment advisor representative in California, consider the following scenario. Sarah, a registered securities agent, frequently engages in conversations with clients about their investment goals and risk tolerance. During these discussions, she often provides her opinions on the general performance of various asset classes and occasionally suggests specific mutual funds that she believes align with a client's stated objectives. She receives no direct compensation for these specific discussions beyond her standard commission on trades executed. Based on California securities law, which of the following best describes Sarah's status regarding investment advisor representative registration? Option A. Sarah is not an investment advisor representative because her discussions are primarily about general market performance and not specific stock recommendations. Option B. Sarah is likely acting as an investment advisor representative because she is providing opinions on securities and suggesting specific investments tailored to client objectives, even if her compensation is commission-based. Option C. Sarah is not an investment advisor representative because the advice she provides is unsolicited by the clients. Option D. Sarah is not an investment advisor representative because she is a registered securities agent and her compensation is based on commissions, not a fee for advice. The correct answer is B. Sarah is likely acting as an investment advisor representative because she is providing opinions on securities and suggesting specific investments tailored to client objectives, even if her compensation is commission-based. Explanation. Scenario analysis. This scenario presents a common challenge in the securities industry where the line between providing general information and offering personalized investment advice can become blurred. Professionals must exercise careful judgment to ensure they are not inadvertently acting as an investment advisor representative without proper registration, which carries significant legal and ethical implications under state securities laws. The challenge lies in accurately identifying when a communication crosses the threshold into providing advice that requires registration. Correct approach analysis. The best professional practice involves clearly distinguishing between providing factual information about securities and offering personalized recommendations or opinions about specific investments. This approach correctly identifies that an individual who provides advice or makes recommendations regarding securities and who holds themselves out as doing so is likely an investment advisor representative. Under the Uniform Securities Act, as adopted by many states, this definition is central to determining registration requirements. The key is the nature of the communication. Is it general information, or is it tailored to the individual's financial situation and investment objectives? When an individual offers to provide advice or makes recommendations and is compensated for it, they are generally considered an investment advisor representative. Incorrect approach is analysis. One incorrect approach involves assuming that simply discussing general market trends or providing factual data about a security does not constitute providing advice. While discussing general trends is permissible, if this discussion is framed in a way that implicitly or explicitly suggests a course of action for a specific client, or if it's part of a broader pattern of communication aimed at influencing investment decisions, it can cross the line. The regulatory framework focuses on the substance of the communication and its impact on the recipient, not just the superficial label. Another incorrect approach is to believe that if no direct compensation is received for the discussion of securities, then registration as an investment advisor representative is not required. While direct compensation is a significant factor, the Uniform Securities Act and state interpretations often consider indirect compensation or the expectation of future business as sufficient. Furthermore, even without direct compensation, if the individual is holding themselves out as an expert or advisor and providing advice that influences investment decisions, they may still fall under the definition. A third incorrect approach is to conclude that if the advice is unsolicited, it does not trigger registration requirements. The Uniform Securities Act's definition of an investment advisor representative is not solely dependent on whether the advice was solicited. The act of providing advice or making recommendations, coupled with other factors like compensation or holding oneself out as an advisor, is what determines registration status. Unsolicited advice can still be considered advice if it is provided in a manner that suggests expertise and influences investment decisions. Professional reasoning. Professionals should adopt a proactive and cautious approach. When in doubt about whether a communication might constitute providing investment advice, it is always best to err on the side of caution and consult with compliance or legal counsel. The decision-making process should involve a thorough analysis of the communication's content, context, and the professional's role and intent. Key questions to ask include: is the information tailored to a specific individual's needs? Is it a recommendation or opinion? Is there an expectation of compensation, direct or indirect? Is the professional holding themselves out as an advisor? Adherence to the specific definitions and requirements of the relevant state's securities laws is paramount. Question 4. Examination of the data shows that a new financial services firm operating exclusively within the state of California offers advice regarding securities investments to its clients, who are all California residents. The firm receives a flat annual fee for its advisory services, regardless of whether any specific securities are recommended or transacted. The firm anticipates having fewer than 15 clients nationwide in its first year of operation. Based on these facts, what is the most appropriate regulatory course of action for this firm under California securities law? Option A. Register as an investment advisor with the California Department of Financial Protection and Innovation. Option B. Assume the firm is a federal covered investment advisor and proceed with SEC registration. Option C. Advise the firm that it is exempt from all registration requirements due to its limited client base and intrastate operations. Option D. Conclude that no registration is required, as the firm operates solely within California and has a limited number of clients. The correct answer is A. Register as an investment advisor with the California Department of Financial Protection and Innovation. Explanation: this scenario presents a professional challenge because it requires an investment advisor representative to navigate the nuanced distinctions between state and federal registration requirements for investment advisors, specifically concerning the definition of an investment advisor and the applicability of exemptions. Misinterpreting these requirements can lead to significant regulatory violations, including operating without proper registration, which carries severe penalties. Careful judgment is essential to ensure compliance with the Securities Act of 1933 and the Investment Advisors Act of 1940, as interpreted by the Securities and Exchange Commission, SEC, and individual state securities administrators. The correct approach involves a thorough analysis of the client's business model and compensation structure to determine if they meet the definition of an investment advisor under the Investment Advisors Act of 1940. If the client provides investment advice for compensation and is engaged in the business of providing such advice, they are likely an investment advisor. The next critical step is to ascertain whether they qualify for an exemption from federal registration, such as the intrastate advisor exemption or the de minimis exemption, or if they are subject to state registration. In this case, if the client's business is solely within the state of California and they have fewer than 15 clients nationwide, excluding certain types of clients, they would likely be considered a state-registered investment advisor in California, requiring registration with the California Department of Financial Protection and Innovation. This approach ensures adherence to the regulatory framework by correctly identifying the advisor's status and the appropriate regulatory body for registration. An incorrect approach would be to assume that because the client's business is limited to California, they are automatically exempt from all registration requirements. This overlooks the possibility that they might still be considered an investment advisor and thus subject to state registration if they meet the definition and do not qualify for a specific exemption. Another incorrect approach would be to advise the client that they are a federal covered advisor simply because they are providing investment advice, without first assessing their client base and compensation to determine if they meet the federal threshold for registration or if they are subject to state registration. This mischaracterizes their regulatory status and could lead to them attempting to register federally when state registration is appropriate, or vice versa. Finally, advising the client that they do not need to register at all, without a comprehensive review of their business activities and client relationships, is a dangerous oversight that ignores the fundamental definition of an investment advisor and the registration obligations. Professionals should employ a systematic decision-making process. First, determine if the entity meets the definition of an investment advisor. Second, if it does, assess whether it qualifies for any federal exemptions. Third, if no federal exemption applies or if the entity is below the federal threshold, determine if it is subject to state registration based on its principal place of business and client locations. This structured analysis ensures that all relevant regulations and definitions are considered, leading to accurate registration and compliance. Question 5. Research into the application of performance-based fees by an investment advisor representative, IR, registered in California, reveals a potential client who expresses interest in such an arrangement. The IAR is considering offering a fee structure tied to the capital appreciation of their portfolio. Which of the following actions best adheres to the regulatory framework governing investment advisors in California? Option A. Implement the performance fee based on the total return of the portfolio, including dividends and interest, and disclose it verbally to the client before signing the contract. Option B. Offer the performance fee to any client who expresses interest, provided the fee is clearly stated in the advisory contract, without specifically verifying if they meet the qualified purchaser criteria. Option C. Ensure the client meets the definition of a qualified purchaser under California law. Clearly disclose the performance fee terms, calculation methodology, and benchmark in the written investment advisory contract, and confirm the fee is based on capital appreciation of the portfolio over a specified period, benchmarked against a recognized market index. Option D. Charge a performance fee based on the increase in the client's net worth, regardless of the portfolio's performance or a specific benchmark, and document this in the contract. The correct answer is C. Ensure the client meets the definition of a qualified purchaser under California law, clearly disclose the performance fee terms, calculation methodology, and benchmark in the written investment advisory contract, and confirm the fee is based on capital appreciation of the portfolio over a specified period, benchmarked against a recognized market index. Explanation. Scenario analysis. This scenario presents a common challenge for investment advisor representatives, IR, in California, managing client expectations and disclosures regarding performance fees. The challenge lies in balancing the desire to attract clients with the strict regulatory requirements designed to protect investors from potentially misleading performance fee arrangements. California law, specifically the Corporate Securities Law of 1968 and its associated rules, imposes stringent conditions on the use of performance fees by investment advisors. Failure to adhere to these rules can result in significant penalties, including disciplinary actions and reputational damage. Correct approach analysis. The best professional practice involves a thorough understanding and strict adherence to the California regulations governing performance fees. This means ensuring that the client is a qualified purchaser, as defined by California law, that the fee arrangement is disclosed in writing in the investment advisory contract, and that the fee is based on a recognized market index or benchmark. Specifically, the fee must be based on the capital appreciation of a portfolio, less any distributions, over a specified period, and must not exceed a reasonable percentage of the net capital appreciation. This approach prioritizes investor protection and regulatory compliance, aligning with the spirit and letter of California's securities laws. Incorrect approaches analysis. One incorrect approach involves charging a performance fee to a client who does not meet the qualified purchaser definition under California law. This is a direct violation of the regulations, as performance fees are restricted to sophisticated investors who are deemed capable of understanding and bearing the risks associated with such arrangements. Another incorrect approach is to implement a performance fee without clearly disclosing the terms, calculation methodology, and benchmark in the written investment advisory contract. California law mandates explicit written disclosure to ensure the client fully comprehends the fee structure and its potential implications. A further incorrect approach is to base the performance fee on a benchmark that is not a recognized market index, or to use a calculation method that is not tied to capital appreciation less distributions. This circumvents the regulatory intent to ensure that performance fees are objectively measurable and tied to genuine investment success, rather than arbitrary or manipulative metrics. Professional reasoning. Professionals should adopt a proactive and compliance-first mindset. This involves staying current with California's specific regulations concerning investment advisors and their fee structures. When considering performance fees, the decision-making process should begin with a rigorous assessment of whether the client qualifies under the law. If they do, the next step is to meticulously draft the advisory contract, ensuring all required disclosures and calculation methodologies are clearly articulated and compliant with the state's requirements. When in doubt, seeking guidance from legal counsel specializing in California securities law is a prudent step. Question 6. Which approach would be most appropriate for an individual representing an issuer in California who is involved in the sale of securities that are exempt from registration under Section 25,100 of the California Corporations Code, to determine if they require registration as a securities agent? Option A. Determine if the specific securities being sold are covered by an exemption from registration under California Corporations Code Section 25,100, and if so, confirm that their role in the sale aligns with the exclusions for issuer representatives in such exempt transactions. Option B. Proceed with agent registration in California to ensure compliance, even if the securities are exempt and their role might be excluded. Option C. Assume that any activity involving the sale of securities necessitates agent registration in California, regardless of the securities exemption status. Option D. Rely on general advice from industry peers regarding registration requirements for selling exempt securities in California. The correct answer is A. Determine if the specific securities being sold are covered by an exemption from registration under California Corporations Code Section 25,100, and if so, confirm that their role in the sale aligns with the exclusions for issuer representatives in such exempt transactions. Explanation. Scenario analysis. This scenario presents a common challenge for individuals involved in financial services, particularly concerning the nuances of registration requirements under state securities laws. The professional challenge lies in accurately distinguishing between activities that necessitate registration as an agent and those that are excluded, thereby avoiding potential violations of the Securities Act of 1933 and the state's specific securities regulations. Misinterpreting these distinctions can lead to significant legal and ethical repercussions, including fines, sanctions, and reputational damage. Careful judgment is required to ensure compliance with the registration provisions of the Uniform Securities Act as adopted in California. Correct approach analysis. The correct approach involves a thorough understanding of the definition of an agent under California securities law and the specific exclusions from that definition. An agent is generally defined as any individual, other than a broker-dealer, who represents a broker-dealer or issuer in effecting or attempting to effect purchases or sales of securities. The exclusion for individuals representing an issuer in certain exempt transactions is critical. Specifically, under California Corporations Code Section 25,013, an individual representing an issuer in connection with the offer or sale of securities that are exempt from registration under Section 25,100, 25,101, or 25,101, one of the California Corporations Code, or in connection with certain federal covered securities transactions that are exempt from state registration, is generally not considered an agent requiring registration. Therefore, if the individual is solely involved in the sale of securities that fall under these specific California exemptions, they would not need to register as an agent. This approach prioritizes a precise interpretation of the law and its explicit exclusions. Incorrect approaches analysis. One incorrect approach would be to assume that any activity involving the sale of securities requires agent registration. This overlooks the explicit exemptions provided by California law, such as those for certain issuer transactions or exempt securities. Failing to recognize these exclusions could lead to unnecessary registration, increased costs, and potential confusion for clients. Another incorrect approach would be to rely on general industry practice or advice from colleagues without verifying it against the specific language of the California Corporations Code. This can perpetuate misunderstandings and lead to noncompliance. Finally, an incorrect approach would be to register as an agent without fully understanding the scope of activities that trigger the requirement, potentially leading to overregistration and unnecessary regulatory burdens. Professional reasoning. Professionals should adopt a systematic approach to determining registration requirements. This involves 1. Identifying the specific state securities laws applicable, in this case California. 2. Understanding the definitions of key terms like agent, broker-dealer, and issuer. 3. Carefully reviewing the specific types of securities being offered or sold and their exemption status under state and federal law. 4. Consulting the relevant sections of the state's Securities Act and any interpretive opinions or guidance issued by the state securities regulator. 5. If in doubt, seeking advice from legal counsel specializing in securities law, or directly contacting the California Department of Financial Protection and Innovation. Question 7. Strategic planning requires a broker-dealer operating in state name to consider how to effectively manage its sales force to ensure compliance with state securities laws. Which of the following approaches best mitigates the risk of sales practice violations and upholds the firm's supervisory responsibilities under the Uniform Securities Act of state name? Option A. Assuming that individual agents will adhere to ethical standards without formal firm-wide policies or specific training on sales practices. Option B. Relying on a reactive approach where compliance issues are only addressed after client complaints are received or regulatory inquiries are initiated. Option C. Implementing a comprehensive compliance program that includes clear policies against high-pressure sales tactics, regular agent training on ethical conduct and suitability, and robust supervisory oversight of sales activities. Option D. Prioritizing the achievement of sales quotas and offering incentives that are solely tied to volume, without explicit guidance on sales methods. The correct answer is C. Implementing a comprehensive compliance program that includes clear policies against high-pressure sales tactics, regular agent training on ethical conduct and suitability, and robust supervisory oversight of sales activities. Explanation. This scenario is professionally challenging because it requires a broker-dealer to balance the need to generate revenue with its fundamental obligation to act in the best interests of its clients and comply with state securities regulations. The pressure to meet sales targets can create an environment where ethical boundaries are tested, making strict adherence to regulatory frameworks paramount. Careful judgment is required to ensure that business practices do not inadvertently lead to violations of the Uniform Securities Act of state name. The best professional practice involves a proactive and comprehensive approach to supervision and training. This includes establishing clear policies and procedures that explicitly prohibit the use of high-pressure sales tactics and emphasize client suitability. Regular training sessions should reinforce these policies, educate agents on the ethical implications of their actions, and provide guidance on how to handle client interactions appropriately. Furthermore, robust supervisory oversight, including regular reviews of sales activities and client complaints, is essential to identify and address any potential misconduct before it escalates into a regulatory violation. This approach directly aligns with the principles of the Uniform Securities Act of state name, which mandates that broker-dealers and their agents act with due diligence and in the best interests of their clients. An incorrect approach would be to rely solely on the agent's individual ethical compass without formal policy or oversight. While individual integrity is important, it is not a substitute for a structured compliance program. This failure to implement clear guidelines and supervisory mechanisms leaves the firm vulnerable to violations, as it does not provide a framework for ensuring consistent ethical conduct across all agents. Another incorrect approach is to focus solely on meeting sales quotas without adequate consideration for the methods used to achieve them. This creates an environment where agents may feel pressured to employ aggressive or unsuitable sales tactics to meet targets, potentially leading to violations of client suitability rules and prohibitions against fraudulent or deceptive practices under the Uniform Securities Act of state name. Finally, an incorrect approach would be to only address sales practice issues reactively, after a complaint has been filed or a violation has occurred. This reactive stance demonstrates a lack of commitment to proactive compliance and fails to prevent harm to investors. The Uniform Securities Act of state name emphasizes a duty of care and supervision that requires firms to anticipate and mitigate risks, rather than simply responding to problems after they arise. Professionals should employ a decision-making framework that prioritizes client protection and regulatory compliance. This involves understanding the specific requirements of the Uniform Securities Act of state name regarding broker-dealer conduct, establishing a strong internal compliance culture, and implementing robust supervisory systems. Regular training, clear policy communication, and consistent enforcement of ethical standards are crucial components of this framework. When faced with potential conflicts between revenue generation and client best interests, professionals must always err on the side of caution and adhere strictly to regulatory mandates. Question 8. The evaluation methodology shows that a registered securities agent in California is approached by their broker-dealer firm to assist in the sale of a new series of preferred stock that the firm is underwriting. The agent has a current Series 63 Uniform Securities Agent State Law Exam license and is registered with the firm. The firm's compliance department has not yet provided specific guidance on the registration status of this new preferred stock offering. What is the most prudent course of action for the agent? Option A. Accept a colleague's assurance that the new preferred stock is permissible to sell without further investigation, as the colleague is experienced in such matters. Option B. Proceed with selling the new preferred stock, assuming that their existing Series 63 license and current registration with the broker-dealer covers all securities offered by the firm. Option C. Rely on the firm's compliance department to proactively identify and address any registration requirements for the new preferred stock without the agent needing to conduct independent verification. Option D. Thoroughly review the offering documents for the new preferred stock to determine if it requires a separate registration or if an exemption applies, and consult with the firm's compliance department or legal counsel if there is any uncertainty before proceeding with sales. The correct answer is D. Thoroughly review the offering documents for the new preferred stock to determine if it requires a separate registration or if an exemption applies, and consult with the firm's compliance department or legal counsel if there is any uncertainty before proceeding with sales. Explanation. The evaluation methodology shows that navigating the nuances of agent registration requirements in California is professionally challenging due to the dynamic nature of securities offerings and the potential for inadvertent violations. A firm's responsibility extends beyond simply filing paperwork. It involves a proactive understanding of when new registrations are triggered. The best professional practice involves a thorough review of the offering documents and the nature of the securities being sold to determine if they constitute a new issue, requiring a separate registration for the agent. This approach is correct because Section 25,110 of the California Corporations Code generally requires registration of securities unless an exemption applies. If the offering is not covered by an existing registration or a valid exemption, the agent must ensure their own registration covers the specific security being offered or sold. This proactive due diligence prevents violations of registration requirements and ensures compliance with California's securities laws, protecting both the agent and the investing public. An incorrect approach is to assume that an agent's existing registration automatically covers all securities offered by their firm, regardless of whether those securities are part of a new offering or a previously registered security. This fails to recognize that registration is often security-specific or offering-specific. Another incorrect approach is to rely solely on the firm's compliance department to identify all registration requirements without independent agent understanding and verification. While compliance departments are crucial, the ultimate responsibility for compliance rests with the individual agent. Finally, an incorrect approach is to proceed with the sale of a security based on a verbal assurance from a colleague that it is permissible without verifying the registration status or applicable exemptions. This bypasses the necessary documentation and regulatory scrutiny required by California law. Professionals should employ a decision-making framework that prioritizes understanding the specific security and offering, consulting relevant sections of the California Corporations Code, and the rules promulgated by the California Department of Financial Protection and Innovation, and seeking clarification from legal or compliance counsel when in doubt, rather than making assumptions or proceeding without proper authorization. Question 9. Cost-benefit analysis shows that a new venture in California involves an individual who regularly facilitates the buying and selling of securities for a fee, acting as an intermediary between investors and issuers. This individual is not directly employed by a registered broker-dealer, but operates independently, generating income from these transactions. Based on the California Corporations Code, which of the following best describes the regulatory status of this individual's activities? Option A. The individual is exempt from registration because they are not employed by a registered broker-dealer. Option B. The individual's activities are permissible as long as the volume of transactions remains low. Option C. The individual's activities do not require registration as long as they do not directly solicit clients. Option D. The individual is likely acting as a broker-dealer and must register with the California Department of Financial Protection and Innovation. The correct answer is D. The individual is likely acting as a broker-dealer and must register with the California Department of Financial Protection and Innovation. Explanation. Scenario analysis. This scenario is professionally challenging because it requires a nuanced understanding of the definition of a broker-dealer under the specific regulatory framework of California. Misinterpreting this definition can lead to significant legal and regulatory consequences, including fines, sanctions, and reputational damage. The core challenge lies in distinguishing between legitimate business activities and those that necessitate registration as a broker-dealer. Correct approach analysis. The best professional practice involves a thorough review of the individual's activities against the statutory definition of a broker-dealer as outlined in the California Corporations Code. This approach correctly identifies that engaging in the business of effecting securities transactions for the account of others, or buying and selling securities for one's own account as a regular part of business, generally constitutes broker-dealer activity. Specifically, if the individual is receiving transaction-based compensation and is not otherwise excluded, they are likely acting as a broker-dealer. This aligns with the regulatory intent to oversee entities and individuals involved in the securities markets to protect investors. Incorrect approach is analysis. One incorrect approach is to assume that simply not being employed by a registered broker-dealer exempts the individual from registration. This fails to recognize that the definition of a broker-dealer is activity-based, not solely employment-based. If the individual's actions meet the criteria, they must register regardless of their employment status with a registered firm. Another incorrect approach is to focus solely on the absence of direct client interaction. California Corporations Code defines broker-dealers based on their role in effecting transactions, which can occur through various means, not exclusively through direct client solicitation. Engaging in the business of buying and selling securities, even if facilitated through intermediaries or platforms, can still fall under the definition if done as a regular business activity. A further incorrect approach is to consider only the volume of transactions. While frequency and scale can be indicators, the fundamental question is whether the individual is engaged in the business of effecting securities transactions for others or for their own account as a regular business. A single, significant transaction, if conducted as part of a business, could still trigger broker-dealer registration requirements. Professional reasoning. Professionals must adopt a proactive and diligent approach when assessing potential broker-dealer status. This involves a deep dive into the specific activities undertaken, the nature of any compensation received, and a direct comparison with the statutory definitions and relevant case law in the applicable jurisdiction. When in doubt, seeking guidance from legal counsel specializing in securities law or directly consulting with the California Department of Financial Protection and Innovation is the most prudent course of action. The focus should always be on compliance with the spirit and letter of the law to ensure investor protection and maintain market integrity. Question 10. The risk matrix shows a potential for increased regulatory scrutiny due to a recent expansion of services offered by a registered securities agent in the state of California. The agent, previously only involved in the sale of mutual fund shares, has now begun offering investment advisory services. The annual registration fee paid was based solely on the mutual fund sales activity. The California Securities Act requires that all registered persons and firms maintain accurate registration information and pay all applicable fees based on their current business activities. If the agent's expanded services trigger a higher fee tier or require a separate advisory registration with its own fee structure, what is the most appropriate course of action to ensure compliance with post-registration requirements? Option A. Wait for the annual renewal period to update the registration and pay any additional fees, assuming the current registration covers the new services until then. Option B. Assume that the existing registration fee is inclusive of all services offered, and no further action is required until a specific inquiry is received from the regulator. Option C. Immediately calculate any additional registration fees owed based on the new advisory services and remit them along with a notification of the expanded services to the California Department of Financial Protection and Innovation. Option D. Proactively contact the California Department of Financial Protection and Innovation to inquire about the fee structure for advisory services, but do not remit any payment until a formal assessment is provided. The correct answer is C. Immediately calculate any additional registration fees owed based on the new advisory services and remit them along with a notification of the expanded services to the California Department of Financial Protection and Innovation. Explanation: the risk matrix shows a potential conflict between maintaining client relationships and adhering to post-registration requirements. This scenario is professionally challenging because it requires a registered agent to balance the immediate need for client satisfaction with the ongoing legal and regulatory obligations that ensure market integrity and investor protection. A failure to properly manage post-registration requirements can lead to severe penalties, including fines, suspension, or revocation of registration, and damage to the firm's reputation. Careful judgment is required to navigate these competing demands effectively. The best professional approach involves proactively identifying and addressing any deficiencies in post-registration filings. This includes accurately calculating and remitting any additional fees or assessments due to changes in the agent's business activities or client base, as mandated by the Securities Act of the State of California. Specifically, if an agent's business activities expand, requiring additional registrations or impacting the basis of their current registration, they must ensure all associated fees are calculated and paid promptly. This proactive stance demonstrates compliance and minimizes risk. For example, if an agent begins offering advisory services in addition to security sales, the registration status and associated fees must be updated accordingly. An incorrect approach involves assuming that existing registration fees cover all potential business activities without verification. This overlooks the principle that registration is activity-specific, and fees are often tiered or based on the scope of services offered. Failing to update registration and pay any additional fees when expanding services constitutes a violation of post-registration requirements under the California Securities Act, potentially leading to penalties for operating with an incomplete or inaccurate registration. Another incorrect approach is to delay addressing potential fee discrepancies until prompted by a regulatory inquiry. This reactive stance suggests a lack of diligence and can be interpreted as an attempt to circumvent regulatory oversight. Waiting for a notice of deficiency or audit not only increases the likelihood of penalties, but also signals a disregard for the proactive compliance expected of registered agents. A further incorrect approach is to incorrectly calculate the required fees based on incomplete or misunderstood information. For instance, misinterpreting the fee structure or failing to account for all relevant business lines can lead to underpayment. This, while potentially unintentional, still results in a violation of post-registration requirements, as the accurate remittance of fees is a fundamental obligation. Professionals should adopt a framework of continuous compliance. This involves regularly reviewing their business activities against their registration status, understanding the fee schedules and their triggers, and maintaining accurate records. Proactive engagement with regulatory updates and a commitment to timely and accurate filings are crucial. When in doubt, consulting with compliance officers or legal counsel specializing in securities law is a prudent step to ensure adherence to all post-registration obligations. Question 11. The audit findings indicate that a registered broker-dealer agent in California, who is also a licensed insurance agent, has been providing personalized recommendations on specific mutual funds and variable annuities to clients. While the agent does not directly manage client portfolios or charge a separate advisory fee, they receive commissions from the sale of these recommended products. The agent believes that because they are already registered as a broker-dealer agent and do not charge an explicit advisory fee, they are not required to register as an investment advisor representative in California. Based on the California Corporations Code, is the agent's belief accurate regarding their registration obligations? Option A. The agent is likely required to register as an investment advisor representative in California because they are providing advice about securities for compensation, even if it is through commissions. Option B. The agent is not required to register as an investment advisor representative as long as the recommendations are limited to mutual funds and variable annuities, which are considered insurance products. Option C. The agent is not required to register as an investment advisor representative because their compensation is derived from commissions on product sales, not from direct advisory fees. Option D. The agent is not required to register as an investment advisor representative because they are already registered as a broker-dealer agent and do not charge a separate advisory fee. The correct answer is A. The agent is likely required to register as an investment advisor representative in California because they are providing advice about securities for compensation, even if it is through commissions. Explanation. 1. Scenario analysis. This scenario presents a professional challenge because it requires distinguishing between legitimate business activities and those that necessitate registration as an investment advisor representative in California. Misinterpreting these activities can lead to significant regulatory violations, including operating without proper licensure, which carries severe penalties. Careful judgment is required to apply the nuances of California's securities laws to the specific facts presented. 2. Correct approach analysis. The best professional practice involves carefully reviewing the scope of services provided to determine if they fall within the definition of investment advice, as defined by the California Corporations Code. Specifically, if the individual is providing advice about securities and is doing so for compensation and holds themselves out as providing such advice, they are likely acting as an investment advisor representative and must register. This approach aligns with the regulatory intent to protect investors by ensuring those who provide investment advice are properly qualified and overseen. The California Corporations Code, Section 25009, defines investment advisor, and Section 25200 requires registration. Providing personalized recommendations on specific securities, even if not directly managing assets, constitutes providing investment advice. 3. Incorrect approaches analysis. One incorrect approach is to assume that because the individual is not directly managing client assets or charging a separate fee for advice, registration is not required. This fails to recognize that compensation can be indirect, such as through commissions on recommended securities, and that advice encompasses more than just portfolio management. California Corporations Code does not limit the definition of investment advice to only asset management. Another incorrect approach is to rely solely on the fact that the individual is already registered as a broker-dealer agent. While broker-dealer agents are regulated, their activities are distinct from those of investment advisors. Providing advice about securities, even if incidental to a brokerage transaction, can trigger investment advisor representative registration requirements if it meets the definition of investment advice under California law and is done for compensation. A further incorrect approach is to believe that if the advice is general in nature and not tailored to specific individuals, registration is unnecessary. California law, like federal law, generally considers advice about securities to be investment advice, regardless of its generality, if it is provided for compensation, and the person holds themselves out as an investment advisor. The key is whether the advice is intended to influence investment decisions. 4. Professional reasoning. Professionals should adopt a proactive and conservative approach when assessing registration requirements. This involves thoroughly understanding the definitions of key terms like investment advice and compensation within the relevant jurisdiction statutes and regulations. When in doubt, it is always prudent to err on the side of caution and consult with legal counsel or the California Department of Financial Protection and Innovation. A structured approach involves 1. Identifying all services offered. 2. Determining if these services constitute investment advice under California law. 3. Assessing if compensation is received. And 4. Confirming if any exclusions apply. Question 12. Stakeholder feedback indicates that a California-based technology startup, which has not previously offered its securities to the public, is eager to raise capital quickly by selling shares to a broad range of investors across the United States, including in California. The startup's management believes their innovative product will generate significant investor interest and wants to proceed with the offering as soon as possible, suggesting that formal registration might be an unnecessary hurdle. As a securities agent licensed in California, what is the most appropriate advice to provide to the startup regarding this offering? Option A. Advise the issuer that they can avoid filing a prospectus by relying on informal discussions and presentations to potential investors, as long as the company is well established. Option B. Advise the issuer that the securities must be registered with the Securities and Exchange Commission, SEC, and a prospectus must be filed with and delivered to prospective investors in California, unless a specific exemption from registration applies. Option C. Advise the issuer that they can proceed with the offering without formal registration, by simply stating that the securities are highly sought after and will generate significant investor interest. Option D. Advise the issuer that they only need to comply with California state registration requirements if they are selling to California residents, and federal registration is not necessary for this offering. The correct answer is B. Advise the issuer that the securities must be registered with the Securities and Exchange Commission, SEC, and a prospectus must be filed with and delivered to prospective investors in California unless a specific exemption from registration applies. Explanation. Scenario analysis. This scenario presents a professional challenge because it requires an agent to navigate the complex interplay between an issuer's desire to raise capital and the regulatory obligations designed to protect investors. The agent must balance the issuer's urgency with the stringent disclosure requirements mandated by the Securities Act of 1933, specifically concerning registration and prospectus delivery in California. Failure to adhere to these regulations can lead to severe penalties for both the issuer and the agent, including rescission rights for investors and potential disciplinary actions. Correct approach analysis. The best professional practice involves advising the issuer that the securities must be registered with the Securities and Exchange Commission, SEC, and a prospectus must be filed with and delivered to prospective investors in California, unless a specific exemption from registration applies. This approach is correct because the Securities Act of 1933 generally requires that all non-exempt securities offered to the public be registered with the SEC. The prospectus, a key disclosure document, must be provided to investors before or at the time of sale to ensure they have material information to make informed investment decisions. In California, state securities laws, the Corporate Securities Law of 1968, also require registration or exemption for securities offered within the state. Incorrect approaches analysis. Advising the issuer that they can proceed with the offering without registration by simply stating that the securities are highly sought after is a significant regulatory failure. Investor demand does not create an exemption from federal or state registration requirements. Furthermore, suggesting that the issuer can avoid filing a prospectus by relying on informal discussions or presentations bypasses the fundamental investor protection mechanism of the Securities Act of 1933. Another incorrect approach is to suggest that the issuer can proceed if they are a well-established company, as the size or reputation of the issuer does not automatically exempt their securities from registration. The focus must be on the nature of the security and the offering process itself. Finally, recommending that the issuer only needs to comply with California state registration if they are selling to California residents, while ignoring federal registration, is incomplete and incorrect. Federal registration requirements apply to interstate offerings, and state registration is in addition to, not in lieu of, federal requirements. Professional reasoning. Professionals must adopt a proactive and compliance-first mindset. When faced with an issuer seeking to raise capital, the initial step should always be to identify the applicable federal and state securities laws and determine if an exemption from registration is available. If no exemption applies, the agent must guide the issuer through the registration process, ensuring all required disclosures are made accurately and timely. Ethical conduct demands prioritizing investor protection over the issuer's desire for speed or convenience. Question 13. Strategic planning requires a registered securities agent in California to maintain accurate and up-to-date information with the state regulator. If a registered agent moves to a new residential address within California, which of the following actions best fulfills their post-registration obligations? Option A. Consider the address change insignificant and therefore not reportable to the state regulator, as it does not affect their employment. Option B. Update their residential address on their internal company records and wait until the annual renewal period to report the change to the state. Option C. Immediately file an amendment to their Form U-4 with the California Department of Financial Protection and Innovation to reflect the new residential address. Option D. Inform their employing broker-dealer of the new address, assuming the firm will handle all necessary regulatory notifications. The correct answer is C. Immediately file an amendment to their Form U-4 with the California Department of Financial Protection and Innovation to reflect the new residential address. Explanation. Scenario analysis. This scenario presents a common challenge for registered agents in California, maintaining accurate and up-to-date registration information with the California Department of Financial Protection and Innovation, DFPI. The core difficulty lies in the proactive nature of regulatory compliance. Agents cannot simply wait for a problem to arise. They must actively monitor and report changes that could impact their registration status. Failure to do so, even if unintentional, can lead to regulatory scrutiny, fines, and potential suspension or revocation of registration. The agent's responsibility extends beyond their personal information to include the firm's operational details, making diligence paramount. Correct approach analysis. The best professional practice involves immediately updating the agent's Form U-4 with the California DFPI to reflect the new residential address. This approach is correct because California's securities laws, specifically under the Corporate Securities Law of 1968, and related rules, mandate that registered individuals promptly report material changes in their registration information. The Form U-4 serves as the official record for an agent's registration, and any change in residential address is considered a material fact that must be disclosed to the regulator. Prompt notification ensures the DFPI has accurate contact information and can effectively communicate with the agent, as well as assess any potential conflicts or issues arising from the new location. This proactive disclosure aligns with the ethical obligation of honesty and transparency with regulatory bodies. Incorrect approach is analysis. Waiting until the annual renewal period to update the residential address is a regulatory failure. California law requires prompt reporting of material changes, not delayed notification. This delay deprives the DFPI of timely information, potentially hindering their oversight capabilities and creating a misleading record of the agent's current status. Notifying only the employing broker-dealer, but not the California DFPI directly, is also insufficient. While informing the firm is a good internal practice, it does not fulfill the agent's individual legal obligation to report changes to the state regulator. The broker-dealer may or may not have a robust system for relaying such information to all relevant state agencies, and the ultimate responsibility rests with the individual agent. Assuming the address change is minor and therefore not reportable is a misinterpretation of regulatory requirements. Materiality in registration updates is broadly defined and typically includes changes in personal circumstances that could affect an individual's suitability or ability to comply with regulations. A change in residential address, especially if it involves a move to a different county or a significant distance, can be considered material and must be disclosed to ensure the DFPI has accurate contact information and can assess any potential jurisdictional or regulatory implications. Professional reasoning. Professionals in California must adopt a proactive and diligent approach to maintaining their registration status. This involves understanding that regulatory requirements are not passive obligations, but demand active engagement. A key decision-making framework is to err on the side of caution when determining if a change is material. If there is any doubt, it is always best to disclose the information to the relevant regulatory body. This principle of transparency and prompt reporting minimizes regulatory risk and upholds professional integrity. Regularly reviewing the requirements of the California Corporate Securities Law and the specific instructions for Form U-4 is crucial for staying compliant. Question 14. Strategic planning requires a registered securities agent in California to maintain accurate and up-to-date information with the state regulator. If an agent moves to a new residence within California, what is the most appropriate and compliant action to take regarding their registration status? Option A. Wait until the annual renewal period for their securities registration to update the address on their Form U-4. Option B. Inform their employing broker-dealer firm of the address change and assume the firm will manage the update with the state regulator. Option C. Assume that since the move is within California, no formal update to the Form U-4 is required as long as the firm's internal records are current. Option D. Immediately file an amendment to their uniform application for securities industry registration or transfer, Form U-4, with the California Commissioner of Corporations to reflect the new residential address. The correct answer is D. Immediately file an amendment to their uniform application for securities industry registration or transfer, Form U-4, with the California Commissioner of Corporations to reflect the new residential address. Explanation. This scenario presents a professional challenge because a registered agent must ensure their regulatory filings are current and accurate, especially when significant life events occur. Failure to do so can lead to regulatory sanctions, reputational damage, and potential client harm. The agent's responsibility extends beyond simply completing forms. It involves proactive compliance and timely notification of material changes. The best approach involves immediately updating the uniform application for securities industry registration or transfer, Form U-4, with the relevant state securities regulator in California. This is the correct course of action because the California Corporations Code, specifically Section 25,242, mandates that every person registered as a broker-dealer agent must file with the Commissioner of Corporations a notice of any change in the information required by the application. A change in residential address is considered material information that must be reported. Prompt and accurate filing demonstrates adherence to regulatory requirements and maintains the integrity of the public record, ensuring that regulatory bodies and the public have up-to-date contact information. An incorrect approach would be to delay updating the Form U-4 until the next annual renewal period. This is a regulatory failure because it violates the explicit requirement for prompt notification of material changes. The California Corporations Code does not permit a grace period for reporting address changes until renewal. This delay could result in missed official communications from the regulator, potentially leading to further compliance issues. Another incorrect approach would be to only inform the broker-dealer firm and assume the firm will handle the update. While internal firm procedures are important, the ultimate responsibility for ensuring the accuracy of the Form U-4 lies with the individual registrant. The firm may have its own internal processes, but the registrant must verify that the update has been made with the state regulator. Relying solely on the firm without confirmation is a failure to directly meet the regulatory obligation. Finally, an incorrect approach would be to assume that since the new address is within California, a formal update is not necessary as long as the firm's records are updated. This is incorrect because the Form U-4 is a state-specific registration document. The California Commissioner of Corporations requires direct notification of changes to the registered agent's information, regardless of whether the change occurs within the same state. The purpose of the Form U-4 is to provide accurate and current information to the regulator for oversight and enforcement. Professionals should adopt a proactive compliance mindset. When a material change occurs, such as a change of address, the first step should always be to consult the relevant state securities laws and regulations to understand the specific notification requirements. This should be followed by immediate action to file the necessary amendments to registration forms. Establishing a personal checklist for compliance matters and regularly reviewing firm policies can help prevent such oversights. Question 15. Strategic planning requires an investment advisor representative in California to assess a new business opportunity presented by a client. The client explains that a friend is seeking capital for a new venture and is offering individuals the chance to contribute funds in exchange for a share of the future profits generated by the friend's management of the business. The advisor must determine if this constitutes a security under California securities law. Which of the following approaches best guides the advisor's assessment? Option A. Assume that because the promoter is well known and respected, the offering is not a security. Option B. Conclude that a private offering to a select group of individuals is inherently not a security. Option C. Accept the promoter's assurance that the arrangement is a simple business loan and therefore not a security. Option D. Analyze the economic realities of the arrangement to determine if it involves an investment of money in a common enterprise, with an expectation of profits derived solely from the efforts of others. The correct answer is D. Analyze the economic realities of the arrangement to determine if it involves an investment of money in a common enterprise, with an expectation of profits derived solely from the efforts of others. Explanation. This scenario is professionally challenging because it requires a nuanced understanding of what constitutes a security under the Uniform Securities Act of 1955, as adopted and interpreted by the state of California. The agent must distinguish between a legitimate investment opportunity and a transaction that falls outside the definition of a security, thereby avoiding potential violations of registration and anti-fraud provisions. Careful judgment is required to assess the economic realities of the transaction, not just its form. The best professional approach involves a thorough analysis of the economic realities of the proposed transaction, specifically considering whether it fits the Howey test criteria, investment of money, in a common enterprise, with an expectation of profits derived solely from the efforts of others. This approach is correct because it directly applies the established legal framework for defining a security. By examining the substance of the deal, whether an investor is contributing capital to a common venture with the expectation of passive income generated by a third party, the agent can accurately determine if the offering constitutes a security under California law. This aligns with the regulatory intent to protect investors from fraudulent or unregistered securities offerings. An incorrect approach would be to rely solely on the terminology used by the promoter, such as calling the arrangement a loan or a partnership interest without further investigation. This is a regulatory failure because the Uniform Securities Act and California's interpretation looks beyond the labels applied to a transaction. If the economic substance of the arrangement meets the definition of a security, the label used by the promoter is irrelevant. This approach risks misclassifying a security, potentially leading to unregistered offers and sales, and violating anti-fraud provisions. Another incorrect approach is to assume that because the promoter is a reputable individual, the offering is automatically legitimate and does not involve a security. This is an ethical and regulatory failure. While the promoter's reputation might influence an investor's decision, it does not alter the legal definition of a security. The agent's duty is to assess the nature of the investment itself, irrespective of the promoter's standing, to ensure compliance with securities laws. A further incorrect approach is to dismiss the transaction as not being a security simply because it is a private offering to a limited number of sophisticated investors. While certain exemptions might apply to private offerings, the initial determination of whether an instrument is a security must still be made. This approach is flawed because the definition of a security is independent of the offering method or the sophistication of the offerees. Failing to identify a security at the outset can lead to overlooking registration requirements or anti-fraud provisions that may still apply even in private placements. Professionals should employ a decision-making framework that prioritizes a rigorous application of the legal definition of a security. This involves understanding the Howey test and its progeny, analyzing the economic substance of any proposed investment, and consulting with legal counsel or compliance departments when there is any doubt. The agent's primary responsibility is to uphold securities laws and protect investors, which necessitates a diligent and informed assessment of every offering. Question 16. The monitoring system demonstrates that a registered agent in California is considering facilitating a sale of a private company's stock by an individual who is not an officer, director, or controlling shareholder of the company. The seller states that this is the only share they own and the only sale they intend to make. The agent needs to determine if this transaction requires registration under California securities law. Which of the following approaches best ensures compliance? Option A. Assume the transaction is exempt because the seller is not an affiliate of the issuer and is only selling their own shares. Option B. Thoroughly investigate and document that the sale meets all criteria for the isolated non-issuer transaction exemption under the California Corporations Code, including confirming the seller's non-affiliate status and the truly isolated nature of the sale. Option C. Proceed with the transaction if the sale would be exempt under federal securities law, such as Regulation D, without further inquiry into California-specific exemptions. Option D. Rely on the issuer's assurance that the sale is permissible and does not require registration in California. The correct answer is B. Thoroughly investigate and document that the sale meets all criteria for the isolated non-issuer transaction exemption under the California Corporations Code, including confirming the seller's non-affiliate status and the truly isolated nature of the sale. Explanation. This scenario presents a professional challenge because it requires the agent to navigate the nuances of securities law in California, specifically concerning exemptions from registration. The agent must distinguish between legitimate business activities that qualify for an exemption and those that could be construed as unregistered securities offerings, potentially leading to significant legal and regulatory repercussions for both the agent and the issuer. Careful judgment is required to ensure compliance and protect investors. The best professional approach involves a thorough understanding of California's securities laws regarding exemptions. This includes meticulously verifying that the proposed transaction strictly adheres to the criteria of a recognized exemption, such as the isolated non-issuer transaction exemption under the California Corporations Code. This approach is correct because it prioritizes compliance with the specific statutory requirements of the state. By confirming that the sale is truly isolated, not part of a larger distribution, and that the seller is not an affiliate of the issuer, the agent acts in accordance with the spirit and letter of the law, safeguarding against potential violations. This proactive verification demonstrates due diligence and a commitment to regulatory adherence. An incorrect approach would be to assume that any sale by a non-affiliate automatically qualifies for an exemption. This fails to account for the isolated nature of the transaction, which is a critical component of the exemption. The regulatory framework in California, like in many jurisdictions, aims to prevent the circumvention of registration requirements through a series of seemingly isolated sales that, in aggregate, constitute a public offering. Relying on a superficial understanding of the exemption without confirming all its conditions is a significant regulatory failure. Another incorrect approach is to rely solely on the issuer's representation that the security is exempt. The issuer has a responsibility to comply with securities laws. The agent also has an independent duty to ensure compliance. Delegating this responsibility entirely to the issuer, without conducting their own due diligence to confirm the applicability of the exemption, is a breach of professional duty and a potential violation of regulatory requirements. The agent must be able to articulate and justify the basis for any exemption relied upon. Finally, an incorrect approach would be to proceed with the transaction based on a general understanding of federal exemptions, such as Regulation D, without confirming that a corresponding exemption is available or applicable under California state law. California has its own specific registration requirements and exemptions, and federal exemptions do not automatically preempt state registration unless specific provisions for coordination or preemption exist. Failing to consider state-specific regulations is a critical oversight that can lead to noncompliance. The professional reasoning process for similar situations should involve a systematic review of the transaction against the specific registration and exemption provisions of the relevant state's securities laws. This includes identifying the issuer, the security, the seller, the nature of the transaction, and the offerees. If an exemption is contemplated, the agent must meticulously verify that all conditions of that specific exemption are met. When in doubt, seeking guidance from legal counsel or the state securities regulator is the most prudent course of action. Question 17. Compliance review shows that a registered agent in California has received a client's proposal to execute a series of trades designed to artificially inflate the price of a thinly traded stock before selling a large personal holding. The agent suspects this strategy may violate California's anti-fraud provisions. What is the most appropriate immediate course of action for the agent? Option A. Proceed with the client's proposed trades after a brief discussion with a senior partner, assuming the partner's approval is sufficient to proceed. Option B. Continue executing the client's proposed trades while advising the client to subtly modify their trading patterns to avoid attracting regulatory attention. Option C. Ignore the client's proposal and continue managing their portfolio based on their previous investment objectives without addressing the new. Concerning strategy, Option D. Immediately cease all further recommendations and transactions related to the client's proposed strategy and promptly report the situation to the firm's compliance department and the California Department of Financial Protection and Innovation. The correct answer is D. Immediately cease all further recommendations and transactions related to the client's proposed strategy and promptly report the situation to the firm's compliance department and the California Department of Financial Protection and Innovation. Explanation. Scenario analysis. This scenario presents a professional challenge because it requires an agent to navigate a situation where a client's investment strategy, while potentially legitimate, raises red flags regarding potential market manipulation or insider trading. The agent must balance their duty to the client with their obligation to uphold securities laws and prevent fraudulent activities. Failure to act appropriately could result in severe regulatory penalties, reputational damage, and harm to investors. Careful judgment is required to distinguish between aggressive but legal trading and prohibited conduct. Correct approach analysis. The best professional practice involves immediately ceasing all further recommendations and transactions related to the client's proposed strategy, and promptly reporting the situation to the firm's compliance department and the relevant state securities regulator in California. This approach is correct because it prioritizes adherence to California's Corporate Securities Law of 1968, specifically its anti-fraud provisions, e.g., Section 25,400 and 25,401, which prohibit manipulative and deceptive practices. By reporting, the agent fulfills their affirmative duty to assist in the enforcement of securities laws and protect the integrity of the market. This proactive reporting demonstrates good faith and a commitment to regulatory compliance, which can mitigate potential liability for the agent and the firm. Incorrect approach is analysis. Proceeding with the client's strategy after a brief internal discussion with a senior partner without reporting to the state regulator is professionally unacceptable. This approach fails to acknowledge the potential severity of the client's proposed actions and the mandatory reporting obligations under California law. Relying solely on internal discussion bypasses the crucial oversight and investigative authority of the state regulator, potentially allowing fraudulent activity to proceed unchecked. Continuing to execute trades for the client while simultaneously advising them to alter their strategy to appear less suspicious is also professionally unacceptable. This constitutes a deceptive practice and an attempt to circumvent regulatory scrutiny. It implies knowledge of the potentially illicit nature of the original strategy and an effort to conceal it, which directly violates anti-fraud provisions and undermines the agent's fiduciary duty. Ignoring the client's request and continuing with their previous unrelated investment activities without addressing the new, concerning proposal is professionally unacceptable. This approach neglects the agent's duty to respond to client inquiries and to assess the legality and appropriateness of proposed transactions. It creates a blind spot regarding potentially illegal activities and fails to uphold the agent's responsibility to act in the client's best interest within the bounds of the law. Professional reasoning. Professionals facing such situations should employ a decision-making framework that prioritizes regulatory compliance and ethical conduct. This involves 1. Recognizing potential red flags that may indicate violations of securities laws. 2. Consulting internal compliance policies and procedures. 3. Understanding and applying the specific anti-fraud and enforcement provisions of the relevant state's securities laws, in this case, California. 4. Promptly reporting any suspected violations to the firm's compliance department, and if necessary, to the state securities regulator. 5. Documenting all communications and actions taken. This systematic approach ensures that client interests are protected while upholding the integrity of the securities markets and adhering to legal obligations. Question 18. Benchmark analysis indicates that a financial services firm in California is evaluating the role of a new employee, Sarah, whose primary responsibilities include processing customer account paperwork, scheduling client meetings for registered representatives, and occasionally answering general inquiries about account balances. Sarah does not directly solicit securities transactions, nor does she provide investment advice. However, during a client call, a registered representative asks Sarah to record a specific order for a mutual fund purchase. Which of the following best describes Sarah's status and the firm's obligation regarding her role in California? Option A. Sarah is not acting as an agent as long as she is supervised by a registered representative and is not directly compensated for securities transactions. Option B. Sarah is acting as an agent of the broker-dealer and must be registered in California because she accepted an order for a security. Option C. Sarah is exempt from agent registration because her involvement in the transaction was incidental to her administrative duties. Option D. Sarah is not acting as an agent because her primary role is administrative and she does not solicit sales. The correct answer is B. Sarah is acting as an agent of the broker-dealer and must be registered in California because she accepted an order for a security. Explanation. Scenario analysis. This scenario is professionally challenging because it requires a precise understanding of who qualifies as an agent under state securities law, particularly when an individual's activities blur the lines between administrative functions and securities sales. Misclassifying an individual can lead to significant regulatory violations, including unregistered agents, improper supervision, and potential liability for the broker-dealer. Careful judgment is required to distinguish between ministerial tasks and those that necessitate agent registration. Correct approach analysis. The best professional practice involves recognizing that any individual who accepts an order for a security from a customer, or who supervises others who do, is acting as an agent and must be registered in California. This approach aligns directly with the definition of an agent under the California Corporations Code, which broadly encompasses individuals involved in securities transactions on behalf of a broker-dealer or issuer. Registration ensures that individuals meet the state's standards for competence and ethical conduct, and that the broker-dealer is properly overseeing their activities. Incorrect approaches analysis. One incorrect approach is to assume that an individual is not an agent if their primary role is administrative, and they do not directly solicit sales. This fails to account for the fact that accepting an order, even if incidental to other duties, constitutes an act of an agent. The California Corporations Code does not limit the definition of an agent to solely those whose sole or primary function is sales. Another incorrect approach is to believe that if an individual is not compensated directly for securities transactions, they are exempt from agent registration. Compensation is not the sole determinant of agent status. The nature of the activity is paramount. Even if an individual receives a salary or other benefits, if they are involved in the securities transaction process as defined by the law, they must be registered. A further incorrect approach is to rely on the assumption that if an individual is supervised by a registered agent, their own activities do not require registration. While supervision is crucial, it does not absolve the supervised individual from their own registration requirements if their actions fall within the definition of an agent. The responsibility for registration lies with the individual performing the regulated activity. Professional reasoning. Professionals should adopt a proactive and conservative approach when determining agent status. When in doubt, it is always best to err on the side of caution and seek clarification from legal counsel or the California Department of Financial Protection and Innovation. A thorough review of an individual's job description and actual duties, in light of the statutory definition of an agent, is essential. This involves understanding that the law focuses on the *act* of selling or facilitating the sale of securities, not solely on the title or primary function of the individual. Question 19. Governance review demonstrates that a registered securities agent in California is providing general market commentary and educational materials about investing to prospective clients. The agent is careful to avoid discussing specific securities or tailoring advice to individual financial situations. Which of the following actions, if undertaken by the agent, most likely require registration as an investment advisor representative in California? Option A. Discussing the potential future performance of specific securities in a general, non-predictive manner. Option B. Offering to develop a customized investment portfolio based on a client's stated risk tolerance and financial goals. Option C. Answering factual questions about the historical performance of broad market indices. Option D. Providing general market trend analysis and educational resources on investment principles without personalization. Correct answer is D. Providing general market trend analysis and educational resources on investment principles without personalization. Explanation. Scenario analysis. This scenario presents a common challenge in the securities industry where the lines between providing general information and offering personalized advice can become blurred. Professionals must exercise careful judgment to ensure they are not inadvertently acting as an investment advisor representative without proper registration, thereby violating state securities laws in California. The core of the challenge lies in distinguishing between factual information and recommendations that could be construed as advice. Correct approach analysis. The best professional practice involves clearly delineating the scope of services offered and ensuring that any information provided is purely factual and educational, without tailoring it to an individual's specific financial situation or investment objectives. This approach aligns with the California Corporations Code, which defines an investment advisor representative as someone who, for compensation, advises others on the purchase or sale of securities, or who issues reports or analyzes concerning securities. By limiting interactions to general market commentary and avoiding personalized recommendations, the individual remains outside this definition. Incorrect approach is analysis. providing specific stock recommendations based on a client's stated risk tolerance and financial goals, even if framed as suggestions, constitutes advising on the purchase of securities for compensation. This directly falls under the definition of an investment advisor representative in California and requires registration, offering to create a personalized investment portfolio for a client, even if the client has not yet committed to purchasing securities, involves the analysis and recommendation of securities tailored to that individual's circumstances. This activity is also a hallmark of an investment advisor representative and necessitates registration. Discussing the potential future performance of specific securities with a client in a way that implies a prediction or endorsement, without the necessary disclosures and registration, can be interpreted as issuing analyses concerning securities. This crosses the threshold into regulated activity. Professional reasoning. Professionals should adopt a proactive approach to understanding their regulatory obligations. When in doubt about whether an activity constitutes providing investment advice, it is prudent to err on the side of caution and consult with legal counsel or compliance departments. Maintaining clear documentation of all client interactions, specifically noting the nature of information provided, is crucial for demonstrating compliance. The decision-making framework should prioritize adherence to the California Corporations Code and the principles of investor protection over the potential for increased business or client engagement through unregulated advisory services. Question: Governance review demonstrates that a registered securities agent in California is providing general market commentary and educational materials about investing to prospective clients. The agent is careful to avoid discussing specific securities or tailoring advice to individual financial situations. Which of the following actions, if undertaken by the agent, would most likely require registration as an investment advisor representative in California? Options: A. Providing general market trend analysis and educational resources on investment principles without personalization. B. Offering to develop a customized investment portfolio based on a client's stated risk tolerance and financial goals. C. Discussing the potential future performance of specific securities in a general, non-predictive manner. D. Answering factual questions about the historical performance of broad market indices. Question 20. Benchmark analysis indicates that a registered agent in California receives a phone call from a long-standing client, MS Alina Vance, who wishes to sell 500 shares of a publicly traded technology stock. MS Vance is a known client with whom the agent has had numerous prior transactions. The agent confirms the current market price and the estimated proceeds. MS Vance agrees to proceed with the sale. What is the most appropriate and compliant course of action for the agent to take immediately following MS Vance's verbal authorization to sell? Option A. Inform MS Vance that the funds from the sale will not be available until the agent personally confirms the trade settlement with the clearinghouse, which may take several business days. Option B. Delay processing the sale until the agent can personally meet MS Vance to verify her identity by reviewing her California driver's license. Option C. Immediately initiate the order to sell the shares through the firm's trading system and ensure the transaction details are accurately recorded for subsequent reporting to the broker-dealer. Option D. Process the sale order but hold the trade confirmation documentation until the end of the business week to consolidate paperwork before submitting it to the broker-dealer. The correct answer is C. Immediately initiate the order to sell the shares through the firm's trading system and ensure the transaction details are accurately recorded for subsequent reporting to the broker-dealer. Explanation: Scenario analysis. This scenario presents a professional challenge for a registered agent in California because it requires them to balance the client's desire for immediate access to funds with their fiduciary duty to ensure compliance with state securities regulations, specifically regarding the timely and accurate reporting of transactions. Misinterpreting or misapplying the rules can lead to regulatory violations, client dissatisfaction, and potential disciplinary action. Careful judgment is required to navigate the nuances of California's rules on agent conduct and record-keeping. Correct approach analysis. The best professional practice involves immediately processing the client's request to sell the securities and then promptly submitting the necessary documentation to the broker-dealer for settlement and reporting. This approach prioritizes the client's instructions while adhering to the regulatory framework. Specifically, under California Corporations Code Section 25,210. Agents are required to maintain accurate and current records of all transactions. By processing the sale and initiating the reporting process concurrently, the agent ensures that the transaction is recorded as soon as practicable, fulfilling their obligation to maintain accurate records and facilitating the client's access to funds within the standard settlement period, typically T+2 for equities. This proactive approach minimizes delays and ensures compliance with the spirit and letter of the law. Incorrect approach is analysis. One incorrect approach is to delay processing the sale until the agent has personally verified the client's identity through a secondary source, such as a driver's license, even though the client is a known, established customer. This introduces an unnecessary delay that is not mandated by California regulations for a simple sale of a liquid security by a known client. While identity verification is crucial, the regulatory requirement is for accurate record-keeping of transactions, not for an agent to act as a secondary identity verification service for routine sales of established clients. This delay could be interpreted as hindering a client's legitimate transaction and potentially violating the agent's duty to act with reasonable diligence and promptness. Another incorrect approach is to inform the client that the funds will be available only after the agent has personally confirmed the trade settlement with the clearinghouse, which could take several business days beyond the standard settlement period. This is incorrect because it misrepresents the settlement process and creates an expectation of delay that is not supported by industry standards or California regulations. The agent's responsibility is to facilitate the transaction and ensure proper reporting, not to personally track and confirm settlement with the clearinghouse, which is the broker-dealer's operational responsibility. This approach fails to act with reasonable diligence and may mislead the client about the timing of fund availability. A further incorrect approach is to process the sale, but then wait to submit the trade confirmation to the broker-dealer until the end of the week to consolidate paperwork. This is a direct violation of the requirement for prompt record-keeping. California regulations, like those governing securities agents generally, emphasize the importance of timely recording of transactions. Delaying submission, even for administrative convenience, means the records are not current, which can impede oversight and potentially mask fraudulent activity. This approach prioritizes administrative ease over regulatory compliance and the agent's duty to maintain accurate and up-to-date records. Professional reasoning. Professionals should adopt a process-oriented mindset that integrates regulatory compliance into daily operations. When faced with a client request, the first step should be to identify the core client need and then immediately assess the applicable regulatory requirements. In this case, the client needs to sell securities. The regulatory requirement is prompt and accurate record-keeping. Therefore, the professional action is to execute the trade and initiate the reporting process simultaneously. This proactive and integrated approach ensures client satisfaction and regulatory adherence, minimizing risk and upholding professional integrity. Professionals should always err on the side of promptness and accuracy when dealing with client transactions and regulatory reporting.